What do we have left? Slogan?
Yes, Your Honor.
All right. Need to unmute him, I think. You unmute yourself, Mr. Slogan? What do you need?
I'm just trying to figure out how to use this, Judge.
All right, can you hear us okay?
Yes, sir.
All right, you might need to put your voice a little closer to whatever you're speaking into.
All right.
Keep your voice up. I can hear you, but not real loud.
All right.
You can't hear anything, just raise your right hand and wave it so we know you lost audio or video, okay?
Yes.
All right, I've got a motion, defendant sworn motion to dismiss on 19 CF 15640. All right, there's a,
Yes, Your Honor. Jeff Mikowski, on behalf of Mr. Slovan. May it please the court? A summary of my argument. Well, I guess I'll go the facts as agreed to by the parties here, although the state did file a demurrer.
they filed a traverse.
A traverse? Traverse and demurrer. All right.
Right, they agree with some and then added to a couple portions, but for starters, that affidavit you're referring to in your C4, can I just get some clarification on that?
Yes, Your Honor.
Let me pull it up. Well, I don't know, was Detective Hendricks present? You guys know the case better than me. Was the affiant from the arrest affidavit present in the courtroom?
Are you referring to Deputy Enriquez?
Well, oh, I got the wrong one pulled up. Hang on. On the wrong damn mess. I think that's the name, yes. Yeah, Deputy Enriquez, was he in the courtroom?
He wasn't, Your Honor. He was not one of the bailiffs. He was called as a result of one of the bailiffs discovering the device.
Okay. Well, two things, because I'm familiar with Benton Court, Mr. Mikowski, and I understand what it stands for, but if you are going to rely on an affidavit, it has to be somebody with personal knowledge that's subject to perjury. Oftentimes they do these arrest affidavits having received information from other people, and that's the affidavit you had. However, the state did file a traverse, which kind of makes a motion to strike the C4 motion to dismiss moot once the, so I'm just giving you this for whatever it's worth. You should have attached the deposition if there was one of the bailiff that perhaps said everything you needed. You could do that in lieu of him swearing to it. And Mr. Bevel, if you don't think it's done properly, you file a motion to strike before you file your traverse, because once you file the traverse, I've seen people file a motion to strike with a traverse already filed, and at that point it's too late. Go ahead, Mr. McKesky. You're going to say something.
Just for the court's awareness, depositions were done after I filed the motion.
I understand. I'm just saying if they had filed a motion to strike, it would probably have been well taken, but
Well, thank you for that edification, Your Honor.
we're past that.
Well, as if the court will indulge me, as to my sworn motion to dismiss, the crux of my argument is that Mr. Slovan's accused of covertly recording an injunction proceeding, which under Florida law is a public proceeding, meaning that there is no expectation of privacy. And there is a State v. Smith that I cite in my motion, as well as the statute. It specifically says that a public oral communication uttered at a public meeting is not subject to this statute. And my position is that the communication made by court personnel, anything that went on during that court personnel. There's microphones in the room, they're lit up, everyone knows it's being recorded. So what Mr. Slobin did, recording with his own device, at least alleged, doesn't rise to the level of criminal conduct. Because again, it's a public setting. And again, what was said was in public. It wasn't at sidebar. It wasn't cleared when this happened. And everyone knew that the proceedings were being monitored and recorded, including the parties.
It's a domestic relations case, correct?
Yes, it is, Your Honor.
Okay.
It was a stalking injunction petition, I believe.
Because not everything in county court is recorded, that's fine. All right. Go ahead, Mr.
All right. At the very least, the court employees, such as the bailiff, were present, and they're not sworn to secrecy.
I don't know that, well, I hear what you're saying, but I don't know that it matters. I don't think under the statute it matters whether it was a so-called big deal or not a big deal. Meaning if it was like a dinner party and you covertly recorded somebody, you'd be in violation of the statute, even though everybody was carrying on conversations in a party format. So I don't know that the driving force is other people were there or may have heard the conversation. But you can correct me if you think the case law is contrary to that. I understand what you're saying is it was a proceeding being recorded in court, but go ahead if you weren't finished.
That's all, Your Honor, for this issue.
All right, state.
Judge, I did file a last-minute reverse in Demurrer in this case, relying on the State v. Young rule that basically states that the evaluation is based on subjective and the objective reasonable expectation of privacy in the setting. Here, its arguments that the court can, as the fact finder, can judge the context for what they are. It's an injunction hearing where not a lot of people are present. There is an expectation it's being recorded by the courts and by the clerks, but not necessarily by an individual person who may have different abilities of disclosure than the clerk of courts would. And in that regards, we'd ask the court to deny the motion.
And you said it was a closed proceeding?
Judge,
I'm shaking your head, Mr. Slobin. I got it, okay? Go ahead, Mr. Bell.
Judge, in all candor, I'm not sure if it was entirely closed. I just do know from my discussions with the deputy that the parties for each case typically wait outside for when their case is called up. So in that regards, it is semi-closed.
Okay. All right. I'll get a ruling to you on that one. Do something. So what else do we have on this case?
I also filed a motion to suppress the search of Mr. Slobin that yielded the sunglasses that are eventually were found to have a recording of the court proceeding.
There's also a motion to dismiss on First Amendment, correct?
There is, Your Honor.
All right, let's do that one next.
Yes, Your Honor. As to the First Amendment claim, Mr. Slobin's accused again of, well, not again, he's being accused of covertly recording an injunction proceeding. And my position is that the First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. And the court proceeding itself was public officials on public property doing things of public interest, meaning the court proceeding itself. And my argument here is he has a First Amendment right to record these matters of public interest.
I think he has a right to hire a court reporter to be present. I guess the question is, does he have a right to covertly record it? I don't know if you make a distinction there, or you think it applies equally. Mr. McCaskey.
I understand the court's position, Your Honor. I'm merely creating a record. I have no rebuttal for the court.
Okay. Mr. Bell.
Judge, just added that I believe it's closely tied to the issue in the sworn motion to dismiss. Depends on the expectation of privacy in regards to this individual context, based on the subjective expectation of the parties.
Does the state agree if there's no expectation of privacy, then the recording is lawful?
Judge, well, I mean, based on the case law, I would have to agree that if the court finds there's no expectation of privacy, then it would be a lawful recording. But our argument is that there is somewhat an expectation of privacy.
And how do you distinguish that from the other cases that found that there was no violation?
Judges, based on who's actually doing the recording, in this case, there is the stance that people know they can expect to be recorded by the clerk. They can expect to be recorded by law enforcement who have an exemption in the statute for surreptitiously recording individuals. But no expectation when it comes to an individual party member who's doing the recording, who, like I mentioned before, has different abilities of disclosure, like sharing over social media, that the courts necessarily don't. And so that distinction plays into a consent to be recorded and what the people's expectations is going into that setting.
Okay. All right, I'll roll on those together. Let's get to the motion to suppress.
Yes, Your Honor. So Mr. Slobin had sunglasses that contained some kind of recording device inside, and those glasses were taken from his person without a warrant by law enforcement. And my position is that this is a unlawful search and seizure. The recovery of the sunglasses without a warrant is a violation of Mr. Slobin's rights under the Fourth Amendment to be free from unreasonable searches and seizures, and that any evidence obtained should be suppressed as fruit of the poisonous trade, specifically the recording. And my position is the state has the burden to show that there was some exigent circumstance to overcome the per se unreasonable nature of a warrantless search.
State.
Well, Judge, I did tell the deputy originally 3 o'clock for the hearing. I'm gonna touch them, see if he can come in earlier. But my stance, the state's stance on this issue is essentially that the defendant was not in custody, and the deputy merely asked to see the sunglasses, and they were willingly and consensually given over to law enforcement. So that will be the state's argument and position. And I expect, speaking to the deputy last week, if I just proffer, I expect that will be his testimony.
Okay, we just gotta get the deputy in. You guys want to break until 2:30?
That's acceptable to the defense, Your Honor.
That would be fine.
I'll let you get it scheduled up. So we'll reconvene at 2:30. Okay.
Thank you, sir.
All right. Thank you, guys. Want me to hit end or leave it as is, Beth?
End it, and then you just pop